Welcome everybody to this event on concrete proposals for FISA reform. I'm Ryan Goodman. I am a co-editor-in-chief of Just Security, which is based here at NYU, and I'm also one of the faculty co-directors at the Reiss Center on Law and Security. The event is co-sponsored by both the Reiss Center and Just Security. My opening remarks are extremely brief because I'm not your main attraction. The catalyst for this event was really set by the Inspector General's report last decade, is the way it feels, which is December of last decade, 2019. And the bipartisan reaction to that report seemed to us an extraordinary opportunity to think towards the future about concrete proposals that are from a nonpartisan, bipartisan perspective of how to fix a broken system. And what better place to have that kind of a conversation but an academic center and at a university, and therefore we pulled together basically a dream team of the people that are some of the most knowledgeable and thoughtful people on this topic. And if you're interested, it's being distributed in hardbound form, but there are 3 pieces in a series that Just Security is publishing on this issue of concrete reforms to FISA that have been written by 3 of our panelists. Just a couple housekeeping matters, and then I'm going to turn it over to our moderator, Adam Serwer. One is there are no recordings of the event, no video or audio, please, no audio or video devices. There will be a public recording of the event, and we will distribute the entire event and the entire video to the public on NYU's website or Just Security's website, but it'll be available to everyone. There'll be also an opportunity for questions from the audience afterwards. You should have index cards available to you by your chairs, and if you have a question, just write it down, pass it to the outside of the aisles. Someone will come and pick them up, and then we'll be able to give that to our moderator. So I just want to turn it over to Adam, but please join me in welcoming this extraordinary panel.
I just want to thank everybody for being here, and I'm going to introduce our panelists. To my left, I have Liza Goitein, Director of the Liberty and National Security Program at the Brennan Center for Justice. To her left, we have Andrew McCabe, who's now a legal analyst at CNN, but is the former acting director and deputy director of the Federal Bureau of Investigation. To his left, we have Julian Sanchez, a senior fellow at the Cato Institute and one of the founding editors of Just Security. And to his left, we have Andrew Weissman, a distinguished senior fellow at the Reiss Center on Law and Security at the NYU School of Law, and a former general counsel at the FBI and senior special counsel for Special Counsel Robert Mueller. So obviously, today we're here to talk about the Inspector General's report on the FISA process and how that went wrong in Operation Crossfire Hurricane, colloquially known as the Russia investigation. But I sort of feel like we should, I assume that people here are familiar with FISA warrants, but just to sort of set a baseline, I'm going to ask, what is a FISA warrant? How do you get one? Why should we care that the Inspector General believes that the process was abused with Carter Page, a former foreign policy advisor to Donald Trump's 2016 presidential campaign?
So good morning, and thanks very much for having me here. So there's a lot packed into your question there, and I think it might help for me to start off by kind of giving folks some context for how FBI agents typically make the decision to pursue FISA in a given case, and the kind of actions that decision puts into motion. So, as most of you probably know, excuse me, the FBI gets its authority, or the outlines of its authority, from the Attorney General guidelines. And the Attorney General guidelines are essentially interpreted for FBI agents in an internal document known as the Domestic Investigations and Operations Guide. So that is the FBI's interpretation of the AG guidelines. It lays out for agents the types of investigations they are authorized to open, under what circumstances those investigations can be opened, the sort of factual predicate that's necessary to open investigations, and it gives very detailed instructions to what investigative techniques you can use at each different level of investigation. So the DIOG outlines 3 levels of investigative activity: assessments, preliminary investigations, and full field investigations. It's important to note that you have to have a full field investigation open and underway before you can make a request to pursue FISA coverage or authority to conduct electronic surveillance under the FISA statute. The factual predication necessary to open a full is pretty broad-based. As the IG referred to it, it is a fairly low threshold. And it is essentially that the agents have an articulable factual basis that reasonably indicates a crime has been conducted or that a threat to national security exists. So once that predication is met, the agent receives authority to open their investigation. They pursue all sorts of logical investigative techniques and investigative steps to get them to the point where they decide that they now need to seek FISA authorization from the FISA court to pursue electronic surveillance. I think it's also important to understand that the purpose of a national security investigation is to mitigate a threat to national security. The purpose is not to conduct a prosecution, a criminal prosecution. It is also not necessarily to, I'm sorry.
Excuse me, can whoever has their phone on, please turn it off? Thanks.
I thought that was just a long hiss, which I barely expected at this point. So the purpose of the national security investigation is to mitigate a threat to national security. Very often, depending on the factual predication you have to open that case, FISA coverage may be the best way or even the only way to get to the bottom of that factual predication. So in other words, if you have information that indicates that a former government employee is now working with a foreign power and selling secrets or classified information that they came into as in the course of their employment, there may be no other way to fully understand whether or not that's happening other than conducting a FISA search at that person's residence or business to see if they are actually hiding classified material in their residence or business, or listening to the content of their communications, which of course you would need a FISA warrant to do as well.
Can you distinguish between a FISA warrant and a criminal warrant, what is commonly known in legal circles as a Title III warrant?
Sure, I will do that, but why don't I walk through kind of the mechanics of getting a FISA warrant, and then I'll compare them to what agents typically do in the field for a Title III electronic surveillance in the criminal context. So once the agent decides they would like to pursue FISA authority, they talk to their supervisor, their field supervisor. So that's the person who oversees the squad in the program they're on. So if this is an agent who is investigating, let's say, Russian counterintelligence matters here in New York, their field supervisor has to approve of their pursuit of the FISA warrant. Once the two of them are on board with the approach they want to take, they reach out to their headquarters supervisor. So the headquarters supervisor, also kind of a low-level supervisor in the bureau, but this is the person whose job it is to kind of work in that, in this case, in this example, it would be someone who worked in the Russian counterintelligence program at headquarters and was responsible for servicing the New York field office, maybe some other field offices in the region. That person would be familiar with the other requests for FISA coverage that are coming out of that squad, or maybe even coming from other field offices in the region. Once the headquarters supervisor is on board, he approaches the FBI General Counsel's Office attorney at FBI headquarters, who has to work with them on that application. The headquarters supervisor and the headquarters FBI attorney then get together, go across the street, or pick up the phone, send them an email, and talk to the attorneys at the Department of Justice, National Security Division, in the office that is responsible for essentially running the FISA program, OI, the Office of Investigations. Those three then work together on the package. It is the DOJ attorney who is responsible for writing the FISA request. As that process is going on, the DOJ attorney meets with the headquarters supervisor and probably the headquarters FBI attorney as well. and receives a briefing on the case, the factual basis upon which the FISA warrant is being sought. A DOJ attorney is likely to have many questions over the course of putting that package together. Factual questions, evidentiary questions, questions about human sources or informants whose information maybe they may be trying to include in the package. All those questions, the DOJ attorney forwards to the headquarters supervisor. The headquarters supervisor then has to turn around and send those questions back to the field office to be answered ultimately by the person responsible for those facts, the case agent who started this entire process. So you can see it's a kind of attenuated, multi-step kind of communication, getting the facts into the package.
So as we now know, based on the IG report, there were a lot of errors in the reports, some of which were mistaken assumptions and some of which were pertinent information that was withheld. Now, the IG did not offer any conclusions about why those errors were in there. And this question is for the panel. Do you have any hypotheses, and what do you base them on?
I'd like to take a stab at that. So the Inspector General did not find any evidence of political motivation or bias, and he looked very hard. It was an extremely thorough investigation. My sense is if there were any such evidence, he would have found it. Not to mention the fact that the notion that the FBI as an institution was biased for the liberal candidate and against the conservative candidate does not comport with it's not plausible. It doesn't seem very plausible. And in fact, the Inspector General did find, we all know about the texts between Lisa Page and Peter Strzok. However, the IG also found texts going the opposite direction, as you might expect. FBI agents who very clearly supported Trump. But here's the thing. I don't think you need to fish around for a nefarious motive to explain what happened here. Investigators are not impartial actors. They are very much invested in the success of their case. They want every tool available to them in order to build their case. And once they come up with a theory of the case, they are naturally going to emphasize facts that support that theory, and they're going to downplay facts that go against that theory. And that's not just in the application, that's in their own minds. It's something Julian has talked about as confirmation bias. That is natural, that is human nature. It's not some sort of nefarious thing. It exists in investigations of all kinds, including regular criminal investigations, but ordinarily there are things about the system, the criminal justice system, that provide a corrective, a pushback against that dynamic. And the problem is that in the FISA system, which is particularly secretive, particularly insular, there is about zero chance that there will ever be some sort of adversarial testing of the application, somebody on the other side saying, hey, wait, no, those facts are wrong. In that setting, that sort of natural dynamic might be expected to play out a little bit the way we've seen it here.
So could I just take a crack at, just to follow up on this lack of adversarial setting, just so people are aware. In the normal criminal case, to use Adam's example of a Title III, where you ask for an electronic interception, that of course is done ex parte as well. The government goes to the court with an agent, and the court either signs it or doesn't sign it. But the odds that that will see the light of day are much, much greater than in the national security context, because if there's a criminal case, the defense gets the application and they make challenges to it. And everybody in the process knows that, meaning the judge and particularly the prosecutor and agents know and are aware that their work will be overseen and challenged. The number of FISAs that have been subject to the adversarial process, as is stated in IG Horowitz's report, are zero. So going in, everyone knows that the FISA does not get reviewed by the defense. So we'll get to sort of reforms, but I think it's really important to understand that there is a lack of adversarial process. So the question that Adam has of what's our speculation as to what could happen here? One, I do think that the lack of an adversarial process, I think, is important, even though there's a lot of internal oversight, and there are a lot of mechanisms to try to catch things. They obviously did not work, and that we'll talk about that. But I also think, if I'm speculating, I mean, I think there's sloppiness, there's a lack of training. I think if you're in the Article 3 side, you're very used to the idea of Brady and impeachment evidence and having to be held to account in court. And that's just second nature. And I think for agents, that's true. I think for FISC judges who are normal Article 3 judges, that's true. But that generally is not the case for the FBI lawyers and the National Security Division lawyers. Some have that experience, but it's not required. And so that's not sort of a natural inclination that people have.
Can I just make two mechanical points that I think shed light on that? First is that in the example I was giving you, it is the case agent in the field who's ultimately responsible for verifying all of the facts that are in that package through something we call the Woods procedure. It is also incumbent upon the case agent on his very kind of ground level to make those fundamental decisions about what facts should be included and what ones are not relevant. So it puts the case agent in a strange, conflicted position of both advocating for the pursuit of this authority, but also responsible for presenting mitigating facts in this ex parte procedure. The other difference that I would highlight in the Title III process, the Title III process is entirely done in the field office. It doesn't go through headquarters to any meaningful way. So you have the case agent working directly with an assistant United States attorney. They put the package together. That U.S. attorney builds the Title III request is also the prosecutor on the case. So that U.S. attorney likely knows the case, knows the evidence, knows the facts, has interviewed some of the witnesses and informants in the case right alongside the agent. So there is a level of transparency as to fundamental investigative fact in the Title III process that does not really exist in the very attenuated process under FISA.
I would say, if you look at, in terms of the explanation here, I think the idea that confirmation bias has something to do with it is supported in part by the fact that if you look at the sort of the pattern of problems and errors over the history of the investigation, the initial application, they had, I think, 7 omissions or misstatements of various kinds, and one exception, I think, they are not, relatively speaking, sort of fatal. I think probably if you fix the errors in the initial application, it's speculative, obviously, we don't know the counterfactual, but probably it still gets granted. The really egregious errors and omissions start showing up in the renewals. That's where they have gathered more information, much of it cutting against their sort of theory of the case, that should have been included and doesn't. And I think that jives with the idea that having essentially convinced the court once, they became sort of wedded to this and the view of the case, and unwilling to kind of go back and sort of re-examine whether claims they'd made that the court had already accepted were still tenable. And so part of that is just a kind of procedural or formal practice. It seems as though all the layers of reviews that occurred, the renewals, focused on the new material. So you have this sort of impressively rigorous-looking structure where a series of different attorneys are looking at the application. But as the renewals are going forward, the material the court's already signed off on isn't getting a sort of second look to say, well, in light of the new information we've obtained, can we still make this assertion confidently? And I think, and this is, again, a hypothesis, but I think there's an interesting distinction between Title III as a criminal wiretap and FISA, in that on the Title III side, the thing you have to show the court, the showing, and the purpose of the surveillance are pretty tightly linked, right? You have to show the court probable cause to believe the surveillance is going to uncover evidence of a crime that has been, is being, or will be committed. And then the purpose is to generate evidence for use in a criminal prosecution, evidence you're going to produce in court, at which point you're also going to have to produce exculpatory evidence and discovery to defense counsel. On the FISA side, the showing is probable cause to believe the target of the surveillance is an agent of a foreign power. But the purpose of the surveillance is not a criminal prosecution of someone as a foreign agent. Very, very tiny fraction of FISA targets are ever prosecuted for anything. The purpose is to gather foreign intelligence. And so there's an interesting disconnect in that a Title III wiretap that is successful in its own terms is going to be one that validates the initial showing, probable cause to believe you're going to find criminal evidence. On the FISA side, you could be gathering genuine foreign intelligence because this one person is talking to people who are in Russian intelligence or they're trying to manipulate the campaign without actually validating your initial presumption that this person is a witting agent of a foreign power. And I think one thing that may happen is once you've got the court to sign off on that initial premise, maybe that question takes a back seat, and the lens for looking at the renewal shifts to, is it justifiable to continue this surveillance in terms of it being productive of FI? Not, do we need to reconvince the court that our AFP determination was correct, agent of a foreign power determination was correct?
I was going to say, I agree that there's a confirmation bias issue, and I also agree that there's this issue of first application versus renewals, but I don't think that that's the answer to what's going on here. I think, my assessment of what was found with respect to the first application is that it was pretty bad. In other words, yes, there were a lot of things.
In relative terms, the
Yes.
later stuff is worse.
But there were things that, as like the former general counsel, I looked at, and it was like, that needs to be fixed. I mean, that I didn't find the first one to be close. And I do think there's confirmation bias, but that problem does exist throughout the system. In other words, that's true in the sort of normal Article 3 setting, where you're used to the idea that you are making an application in the court, but you're also responsible for fulfilling your obligations under Brady. And I'm not saying that that's a perfect system, but I think people are used to that. But so I think it's an issue. I think that there's an exacerbation of it here when you don't have an adversary. And I also think that the Woods procedure that Andy talked about, which is it's a system that has come up with because of prior problems in FISAs where what is necessary is for an agent with attorneys from the National Security Division who double check everything. They go through to see that is everything that is put into the FISA application supported in writing. But they're looking for the assertions and to see that every assertion there's some confirmation. They're not looking for what is the other evidence out there that might cast doubt on what was being asserted. So I'm not sure the Woods procedure was geared to what is, I think, the large take-home from the IG report.
And that's changed now, right? I mean, that's the good news, is that the FBI director has said that he is putting in place a number of different measures, including, excuse me, a requirement that the inclusion of exculpatory evidence that actually be included in the FISA package that's sent over to DOJ, and that it's revealed to the court. And that is not only now a requirement, but it's part of the forms they have to fill out. It's a check they have to make on the box. And I mean, yes, that kind of thing may seem like a rote exercise, and at worst, it sort of devolves into a rote exercise. But it is something that it did not exist before. I mean, currently the procedures say that agents have to disclose all material facts, but it doesn't explicitly say that that includes facts that cut against the agent's case. And if the agent is trying to build the strongest possible case that he or she can to put before the Justice Department and then the FISA court, that may not be the first thing that he or she thinks of is, well, what evidence would go the other way? So making that explicit is an important step.
Given the high stakes of surveilling a former presidential campaign aide, why should Americans have any confidence that even worse errors or abuses are not occurring in other applications?
I'd love to jump in here because I don't think we should have any confidence in that. I think we should reach the opposite conclusion. I mean, given that there were in fact actually extra layers of review in this process because of the political sensitivity. I think, in a situation where you don't have that layers, you're all the more likely to see this kind of application padding or slanting of the facts, if you will. And in the average case where this might be happening, the target's never going to learn that the surveillance happened, let alone be able to trigger an inspector general report and outraged hearings held by members of Congress. And even though there was no evidence of bias in this case, I do worry that bias could exist in other cases. And I'm not necessarily talking about some grand scheme to take down a presidential candidate. I'm talking about your basic, everyday, conscious or subconscious prejudice based on factors like race or religion. And I think that we have seen some evidence of that. I mean, a few years ago, there was a report about FISA orders that had been obtained to conduct surveillance of 5 prominent Muslim American leaders. And these include a former Department of Homeland Security official, the head of the largest civil rights Muslim organization in the United States, a professor of international relations at Rutgers University. These were respected members of their community. And I would love to see the IG do a deep dive onto those applications, but given what we know, I think there is reason to worry that there was anti-Muslim bias at work. In 2010, the Inspector General released a report showing that FBI agents had been improperly tasked to go monitor the activities of certain left-leaning ideological advocacy groups, including PETA, People for the Ethical Treatment of Animals, and Greenpeace, and the Catholic Worker, showing a potential bias against, again, left-leaning advocacy groups. And then, of course, there's the fact that the FBI came up with this category of Black identity extremism, which doesn't even exist, as a basis for one of its investigative priorities. So yes, I am definitely concerned that this could be happening and that it could be happening in situations where bias actually is at work as opposed to this case.
Wow, there was a lot there. I agree with you that we have very good reason now to go back and look for the same sorts of flaws in other FISA requests that the IG found in this high priority FISA that certainly had a lot of people looking at it. But again, those the kind of high priority nature of this FISA and the attention that it garnered as a result of that was the same sort of focus that we typically put on FISA, which is coming from a perspective of evaluating the adequacy of the predication based on the facts that are included in the package. And I think the strongest takeaway for me is that once again, it's kind of like the kind of misplaced confidence in the Woods procedures and the Woods review. If you are simply going back to look at the documentation that substantiates every fact in the package, you are not even getting close to that very fundamental decision-making that goes on at the agent level, determining what is actually mitigating, what other contrary information needs to be brought to the attention of the attorneys and the court. Reasonable people can have very different opinions on those decisions, but at the end of the day, in the FISA process, it is that case agent is really the only person in a position to know the universe of those facts, of those informants, of the results of all those interviews, and to make that kind of initial culling of fact by themselves. I think that is an inherent weakness in the process that we're never going to fix until someone has visibility into the case file in the same way that the agent does. That's what you miss on the FISA side that you have on the Title III side.
I think that's really worth stressing. I think Andy and I both have been at headquarters at FBI, and we both worked in the field. I was a prosecutor, Andy was an agent in New York. And there really is a fundamental difference when I would seek a Title III with an agent. The amount of rigor, I mean, the agent knew the case completely, and I knew the case completely, and there would have been no ability to say, why didn't you tell me that? I mean, everything was shared. I mean, yes, there can be a miscommunication, but it would be rare. I think at headquarters, where you have an agent, an FBI lawyer who has not usually, might happen, but wouldn't necessarily have been following the case, and then you have a DOJ lawyer, and they're all sort of reporting to different people. And one of the take-homes that I'll be interested in seeing what happens with the follow-on IG report is this sort of lack of ownership. And you could imagine an agent saying, well, I would tell you whatever you wanted to know, why didn't you ask me? And the attorney saying, well, why didn't you tell me? Now, I mean, all of that is a lack of training, and it's very upsetting, but I think that breakout is not helpful. I find that less likely to happen in the field.
There is sort of a potential Kitty Genovese problem, right? A sort of diffusion of responsibility problem. You say, well, more layers of review will improve the process, but in a sense, the more eyes that are on something, the sort of less ownership and obligation any particular person feels. Because, well, it's, if we get it wrong, 5 other people got it wrong, and there's 4 other eyes on this, so if I don't catch something, someone else will. But also, this is, I think, a pattern we see to some extent with compliance issues across the intelligence community. If you think back to other instances, not necessarily under FISA Title I, but other surveillance authorities like the bulk collection program initially disclosed by Edward Snowden, that where there are these compliance incidents that ultimately get reported to the court, very often there is a sort of disconnect between sort of analysts and lawyers, or between the tech people and the lawyers, where the lawyers are representing something to the court that doesn't quite match the understanding of the technical people, and there's a kind of disconnect in their understanding of what facts are salient to represent the court, or how something is being represented that doesn't match the kind of operational side or the practical side. And so I think, in part, just the sort of incredible complexity of a lot of these operations creates that issue of no one really understands the entire picture, and so you inject the potential for slippage as a representation of how things are going, sort of percolates its way through several hands on its way to the court.
So we've talked about this a little bit, but the omissions from the application seem more significant than the mistakes, in the sense that any investigator could make a mistake, but not offering up potentially exculpatory information seems more deliberate. Now there is, Liza mentioned earlier that there have been some changes made in order to prevent that from happening again. But is there anything else that can be done to ensure that when investigators come across potentially exculpatory information and they don't want to let go of their theory of the case, that they are more likely to include it in an application so that it's not something that ends up in an IG report years later?
I think that gets to kind of what we've just been discussing. I'm not surprised that the IG didn't find evidence of deliberate omissions. And I think that, again, frames this issue as one in which you're talking about decision-making. You're talking about a judgment call on the part of the only person who really has the insight to know both sides of that argument. I think, it is similar to the obligations under Brady, not perfectly, and it certainly doesn't carry the same sort of we'll be fighting this out in court in an adversarial process in the way that Brady does. But agents on the national security side understand that that's part of their obligation. Where things fall apart is when they don't see things as being necessarily mitigating or needing to be reported to the court. So again, to use the Title III example, an agent might, working with his U.S. attorney, say, hey, we interviewed witness X, and witness X said that our target was at the scene of the arson, so I want that statement in the Title III request. The difference here is the U.S. attorney is in a position to be able to say, no, I sat in that interview with you. And in addition to saying that, witness X also said that, he couldn't remember anything because he'd, abused substances for the last 10 years of his life, and he couldn't pick one person out from another person. And so if we're going to put in his identification of the subject at the scene of the crime, we also need to let the court know that this is a person with terrible recollection and what have you. So like that fundamental fight, that argument doesn't happen on the FISA side, and all of the responsibility is left on the shoulders of the case agent to make those decisions. My concern with some of the measures that the FBI has identified now is to fix this issue going forward. None of them are bad, but many of them seem designed simply to make it easier to hold the agent accountable after the fact, and there is a value to that, but very few of them seem designed to get to the heart of that. How do we make sure, who is it that can check to make sure that the decision-making about what's relevant and what's not is being done in the way that we want?
Well, one of the more disturbing things about the process that led to the initial application had to do with whether to disclose that Page had a prior relationship with the CIA. And this might color your interpretation of the fact that he continued to be in contact with Russian intelligence agents. And they ended up, I think maybe because of a misunderstanding by the case agent about the time frame in which he had been designated as an operational contact, said, well, no, that's out of scope of our investigation. Turned out to be incorrect, so we don't need to include it. But so they had this meeting about whether this was a potentially material fact that they had to disclose to the FISC. And my intuition would be, if you are having a meeting about whether a particular fact is potentially material, it is potentially material. And the sort of reading between the lines, the tenor of that discussion seemed to have been, is there a rationale for not, can we find a reason that we don't need to disclose this, as opposed to, why not play it safe and disclose it?
In my experience, that's the way all those meetings are resolved. I haven't had a conversation with a U.S. attorney or a DOJ attorney, for that matter, in which we're arguing over whether or not to disclose something that ends with anything other than let's just disclose it in the abundance of caution. So my concern is for the issues that don't find their way to a meeting like you described.
So, and I have no doubt that there are cases where that is a difficult judgment call. I think some of the examples in the Page applications are examples where if the agent was aware of an obligation to disclose exculpatory material, there can be no question that the information was relevant. Things like Steele's primary subsource was saying things in an interview that contradicted what was in the report. I mean, clearly that is material and something that should have been disclosed. So while I do agree, it would be good to have more sort of front-end involvement of other people who could help to sort of assess those questions. I think the back-end accountability measures are important. And one thing that I've actually just been thinking as we've been sitting here talking is, why not have a Brady obligation? Why not codify an obligation for the Department of Justice to disclose any facts that cut against, that they're aware of, that cut against a finding of probable cause, and tie that to the exact same remedy as in Brady, an exclusionary remedy, where they don't get the FISA order if they have knowingly or negligently withheld facts that are clearly material.
So one thing, I agree with the various assessments, and I agree with Liza that these things were not close. This isn't like you could have a long debate about, gee, I don't think we should turn these over. And I do think there obviously are there are issues that can be assessed to the agents involved, but I think one of the areas where I don't think the IG, at least in this report, did a particularly good job of looking deeply is, and I hope when he does the secondary review, is looks more closely at the lawyers. This is a legal process. You're going to a court. You're going to the FISC. Agents, although they may have a law degree, they are not practicing lawyers when they're in the field getting a FISA. They are relying on the lawyers at the FBI General Counsel's office, and then ultimately the person who owns the process, who actually is writing it, who makes the final decision as to whether it goes forward and what it looks like, is the NSD lawyer. Obviously, the agent has to sign off on the facts, but that's after there's been a vetting by the lawyer. So to me, this issue of everyone obviously knows they have a Brady obligation to the court, meaning it is just not conceivable to me that lawyers don't know, particularly in an ex parte setting, that you have an obligation to reveal everything to the court that could possibly undermine your application. And in fact, there's zero reason not to. I mean, let the court know, and if you think you still have probable cause, the court's going to agree with you. So I think that there needs to be a much closer look at the training of the lawyers, both on the FBI side and on the national security side, as to what exactly, what is the review that's going on, and how closely are they asking the right questions. In the Title III setting, one of the obligations of Brady is you actually have an obligation to look for it. It's not that it's just sort of like, oh, gee, what do I know? You actually have to figure out what are the likely sources of Brady, find it out, and then if it's actual Brady material, you have to turn it over.
That actually goes right into my next question, which is, the Department of Justice is meant to oversee the FISA process, and in the Inspector General's report, he made a point of saying that the higher-ups at DOJ seemed unaware of the factual issues with the applications and subsequent renewals. But obviously, I think the panel seems to be in agreement that DOJ lawyers need to know a little bit more about this process in order to make sure that something like this doesn't happen again. Are there structural changes that could be made to make sure that higher ups at DOJ are not sort of in the dark when applications like this one have problems?
Well, so that is a huge issue. Having been at the FBI, where it's such a different animal than being in a U.S. Attorney's office, where there are 100 prosecutors in a large office. When you've got 36,000 employees, how you frack down into to know what is happening at the ground level and what the truth is, means that you have to have, your bosses have to be setting a tone of absolute rigor, and you have to be willing to be a pain in the ass to sit down and find out exactly what is going on. I think as a practical matter for your everyday FISA, that is not going to happen. That is, you're not going to have the general counsel of the FBI or the deputy director sitting down talking to the line agent and their supervisor on that with that granularity. But with something like a Carter Page FISA, that clearly is or should be happening. But it's a really hard issue to get down to that level.
Yeah, I mean, even, and I know this is like inconceivable to most people, but even in the context of the Carter Page FISA, it is incredibly challenging to maintain that level of understanding of day-to-day investigative developments and be able to bring that knowledge into your review of the package. So in the example that you raised about which affected the renewals, where a subsource of Christopher Steele was interviewed and made comments about Steele's reliability or whatever it was. That, I think, as I now know only from reading the IG report, I think that was in the middle of a 72-page 302. So 302 is the report of an interview. So when the agents conduct an interview, they come back to the office and they write up a 302 that includes all the information that the witness or informant or whoever it was gave them. So those are the kinds of investigative developments that didn't make their way into the package. Absolutely unforgivable. I'm not defending the mistakes in the package, but trying to figure out whether or not the general counsel is ever going to be reading every 72-page 302 on every significant investigation, which I hate to tell you, there were other significant investigations going on at the time of the Carter Page FISA. It's just really hard to see how that's going to happen. Somebody essentially outside of the case, so immune from the bias and the motivation of getting that surveillance up, but who also has the same kind of access and vision into the investigation as the case agents and the case agent supervisor. I mean, structurally, I don't know what that looks like in DOJ, whether that is a...
I mean, can you have a FISA ombudsman team who it's like 3 people whose job is just to look over these things and make sure that
Think
they're
of
done
it as the
properly?
Office of FISA Opposition.
Right. Well,
I mean, it's-
so I think there's 2 answers. That one is that was the idea for the FBI General Counsel lawyers and the National Security Division lawyers, which is the same function that happens in the field within AUSA, which is that you are doing that. In other words, one of the upsetting things here is that that structure is in place and did not work. Now, there is a process for having this kind of auditing and double checking, and wasn't working. This is not a solution that cures all evils, and I think there are many other remedies that are needed. But I think there now is a precedent for, and there's an ability to have defense counsel involved in the process. Just to give you a quick overview, the court, the FISC, always had the ability to appoint amicus. After the Snowden revelations about the so-called 215 program, that's the bulk data collection of telephone records, because of that, what was viewed as the unique problem of how did that get through without sort of sufficient vetting. And as courts passed on it, the DOJ passed on it, the Congress knew about it, all these people knew about it, but the particular argument for why it was relevant as required by the statute was pretty thin. And in light of that, the court said, you know what, we're going to create a panel of pre-cleared amicus who have security clearance, and then as difficult or new legal issues come up, the court can decide that they will appoint somebody who's pre-cleared to review this. Well, now we have more data, right? So that was the solution for that problem. And by the way, the first time that the 215 program was subjected to an adversarial process, it was struck down. So as soon as that you had defense counsel challenging it in the Second Circuit, the court said, no, it doesn't meet the relevant standard. Whereas under the FISC, where the FISC for years had approved it, there wasn't this other voice saying, here's the issue. And this is why, I mean, I've been a prosecutor for most of my life, but I've been a defense counsel. This is why the system, it really has a strong presumption of an adversarial process. Well, now we know that there's an additional problem, and it may be, I think that everyone here agrees, if it's happened in a high-profile matter, there's reason to really be concerned about this not being aberrational, but being more emblematic. And that may or may not be true, but it certainly is a risk. So to me, there's very little downside in expanding the amicus role so that they have the ability to see every package and decide to weigh in or not. And the usual downside, and then I'll shut up to that, is doesn't that slow up the process? And what if there's an emergency? And my answer to that is, well, if there's an emergency, the government can make an application to the FISC saying you need to act on it quickly. But it is without prejudice to amicus being heard after the fact to challenge things. And personally, I think if I were a judge, I'd like that. I mean, I'd have another person looking and thinking about what are the issues I might be missing.
I mean, another way to have at least the potential in some subset of cases of an adversarial process is tell the target, which we do 100% of the time in the criminal context. Title III waiver types is over. Whether or not charges are brought, the target is notified. And that's generally, I'm sort of stretching back many hundreds of years, a critical component of the reasonableness of a search, and therefore the constitutional status of a search is notice to the target. It can be delayed for good reason, but ultimately the target is notified. And there are reasons, I think in some cases good reasons in the national security context, why it might be necessary in some instances to keep surveillance permanently covert. But the current sort of statutory presumption is 100% of the 1,500 to 2,500 FISA warrants that are issued every year are covert forever. And not because when it concludes some showing of good cause or exigency was made, but by default. And I think, again, there may be cases where that can be justified. But we shouldn't just categorically say, well, because the purpose of this surveillance ex ante was to gather foreign intelligence, that purpose sort of settles the ex post question of whether you're justified in permanently concealing the search from the target. I think that is the kind of thing that should have to be justified on a case-by-case basis. And sometimes there will be very good reasons for protection of sources and methods that the target can't learn about it. But sometimes that won't be the case. And I think the prospect of, if this turns out to be a case where you can't make that argument, you may indeed have that genuinely adversarial, not a sort of pseudo-adversarial, but a genuinely adversarial process may create a different set of incentives.
And I would agree with Julian, and I want to explain why I think that is even more important than having an amicus be part of the process, which I favor having an amicus be part of the process because I think that an amicus can raise civil liberties issues and other relevant issues that come up with the application. But when it comes to ferreting out factual inaccuracies, the target is in by far a better position than the amicus. If you look at the problems in the page applications, there's no way that an amicus would have been able to identify the vast majority of those because an amicus would not be able to identify 100 witnesses like the Inspector General did and would not have full access to every single document in the case file and correspondence. And the amicus would not know, for example, that Page was actually a CIA source during a particular period of time. Carter Page would know that. And generally, because the application relates to the actions of the target is in the best position to know where there are inaccuracies and to probe the origin of those inaccuracies. So I think it's very important to develop some way in which to bring targets into these proceedings at a minimum in cases where the investigation actually does culminate in a criminal proceeding, whereas we mentioned earlier, the rule of thumb right now is the target is maybe notified, there's a question mark there, of whether the surveillance happened, but never gets to see the application for surveillance and therefore has absolutely no meaningful opportunity to contest it. And that needs to change.
Is there any way to make a secret process like this respect the civil liberties of Americans being targeted, or does secrecy make it inherently ripe for abuse?
So, there are a lot of Western democracies that deal with this issue. It's balancing security and civil liberties. We're not the only nation that's had this issue, and you have a British example and Canadian examples, you have Israeli examples of how do you deal with this. There is a need for secrecy. I mean, just the most obvious one, even in just a normal criminal setting, you don't tell a criminal target, exactly what you're investigating while the investigation's going on. And even I agree that there should be greater notice, but the issue of who you notify and whether they get full access to the FISA package is fraught. And I would not be in favor of that just as a blanket matter because there's so much intelligence information that you really do not want going to these people. But the issue is how do you protect civil liberties and give some counterweight so that the court is hearing, and this is all a court process, but the court is hearing from somebody else. And I agree it's a very challenging matter because I agree with Liza that the target is going to be a useful source of the information, but I don't think it's in every case that you'd want to give the target the FISA package.
So just to clarify my suggestion from earlier, I didn't necessarily mean that in every case the defendant would have full access to every word in the FISA application, but rather that it would proceed as it proceeds in criminal cases that are not foreign intelligence cases, where when there is classified information that the government is relying on, there's something called the Classified Information Procedures Act, which governs how classified information can be handled in that setting. And the law presents a range of options that the government can essentially choose to try to protect classified information while still moving forward with the prosecution. And it has, worked. Put it this way, civil liberties advocates in general don't really love it, but I will say that it has been used in criminal investigations involving espionage and other very high-stakes national security matters, and it has been used successfully in the sense of not, leading to, tremendous national security harm. So that's the kind of thing I was proposing. On the more general question, secrecy is corrosive to accountability, to truth finding. The adversarial process is the best way any legal system has come up with to find the truth. The idea isn't to put a thumb on the scales for the defendant, it's to figure out what the truth is. Secrecy is inimical to, it plays a corrosive role in the justice system. That doesn't mean it's not sometimes necessary, but when it is necessary, you need to make sure that the protections on the other side are stronger, not weaker, than they are in a context where we don't have this secrecy. And right now we kind of have the opposite situation. So if you look at what's called the minimization procedures for electronic surveillance in an ordinary criminal setting, that's what they can keep, what they have to discard, that sort of thing, how they can use it. Those are so much stricter in the context of a normal criminal investigation than they are in a foreign intelligence surveillance investigation. It should be the opposite. You have these factors that are pulling in the direction of potential for things to go wrong, potential for abuse, potential for sloppiness, whatever it may be. You need to make sure that the countervailing measures are stronger, certainly, than they are right now.
So I think we've discussed this a little bit, but I think there seems to be a lot of agreement that the process would benefit from being more adversarial than it already is. One suggestion is to empower the amicus, another suggestion is to sometimes inform the target. Are there any other ways to make the FISA process more adversarial while still preserving its essential function, other than the ones that we've discussed so far?
I think also, these kind of deep dives, there was this fascinating exchange between Senator Marsha Blackburn and I.G. Horowitz at the Senate hearing after this came out. She said, so let me ask you, how often do you find, these kind of mistakes in a FISA application? And I think that kind of the point of the question was, she expected him to say, this is extraordinary, there's nothing like this is normal, and so it must be that this was some kind of weird vendetta against Trump. What he actually said was, I have no idea. We've done kind of high-level reviews, but this level of sort of a deep dive into a particular FISA process, we haven't done before, so, I hope it's unusual. And that should be a little disturbing. The answer to that question of, well, is this an unusual level of errors, is, I just don't know. And, maybe it's just very natural, right, that things will tend to slip if no one is actually checking after the fact. If whatever your job is, any office you work in, if no one is checking whether you made mistakes when you file it, that affects how cautious you are. And again, you couldn't possibly do this kind of thing for every one of 1,500 FISA applications. But you could do 5 or 10, and maybe a little bit less exhaustively, and knowing that is, there's the potential for that, may be helpful.
The one thing that's worth noting, though, is that, I understand and I agree with what you're saying, but in the FISA process, there actually is more structural oversight than in the Title III context. There are so many hoops that the agents and lawyers go through, including that in order for it to be submitted to the court, there are very few people who can sign off at the FBI and DOJ side. It has to be presidential appointees who have the ultimate say, which is very, very high-level people at the department who need to see it. And the idea is that people know this is going to get that level of scrutiny, and you shouldn't put your boss's boss's boss in a position of signing off on something that's got errors in it. And then there's the Woods procedure, which is not typical of a Title III. And there are an enormous number of computer systems and oversight systems. So the Department of Justice lawyers with the OGC, FBI lawyers, go to the field offices to check on the Woods review to make sure. So there is an audit system. So, I mean, I'm not saying that it worked. It obviously did not work. But I'm saying that there actually is an enormous amount of structure. And I think it's not that there wasn't structure, it's that it wasn't structure that was actually capturing the issues in an intelligent way that were identified by the Inspector General.
Yeah, I think that's right. And to be clear, we don't know. I don't believe the Carter Page FISA was ever subjected to that standard oversight ex post facto review by DOJ attorneys that takes place at 25 to 30 field offices a year. So we can't say conclusively whether or not they would have come up with uncovered some of those mistakes. But I think what we can say pretty confidently is that although we are doing oversight and we are looking at, whether the facts in the package have been properly substantiated or verified by documents and everything else, we're not looking at the whole picture. And I'm just not sure that a team of DOJ attorneys who flies into the field office for a week and pulls a random sample of FISA packages is going to really be equipped and well-placed to do the kind of review that you're talking about that clearly needs to be done on a regular basis. This is literally taking the FISA application and matching it up against the broader investigation and making a determination as to whether or not every development that was relevant to the FISA made its way in there. I just don't know that. And I'm not sure. I think the amicus program is a strength and something that should be enhanced. But again, it is also a bit after the fact, and it's done by folks who don't have access to that sort of material. So I've been thinking more about, a permanent office of DOJ attorneys and assisted by FBI agents to actually perform that sort of review on packages in a real-time basis. Like, for instance, the Office of Inspector General. So we have an Office of Inspection within the FBI that is responsible for conducting internal investigations. And every complaint that comes to the inspection division about a person or a violation of policy, whatever it might be, the DOJ Inspector General gets a first look at all those complaints and gets to basically take on whichever ones they think they need to do themselves because they're about people in high positions or they're novel issues that they feel like they want to look into. You can almost imagine a similar process on the FISA side. If there were a dedicated team of attorneys and agents whose job it was to essentially check the work of FISAs in place. They wouldn't do all 1,500, that's not possible or realistic, but knowing that that's sort of an active kind of fact-checking and investigative checking process is out there and might scoop in some percentage of FISAs a year, I think would be a very powerful motivation to ensure that things were done correctly. And it would also give them a position to weigh in with the OI attorneys who are responsible for the package before it goes to the court.
So like a FISA red team of sorts?
Essentially. I'm not going to name it because I don't want to own that.
But it would have to be tied to accountability. That's the thing. I mean, if DOJ does all these reviews and finds a bunch of problems and the answer is, oh, well, then it's going to happen again. And part of what we're talking about here, which we haven't identified as such yet, is culture, is the culture within the agency or within the part of the agency or the part of the department that's working on these FISA applications. And culture is notoriously difficult to change within an organization. But one of the things that people who study this issue point to is the need to connect culture and accountability. And so if there is not some understood consequence to leaving clearly material facts out of an application or misstating facts or whatever the case may be in a way that is either deliberate or reckless or negligent, if those consequences are not in place, known to everybody, and strictly enforced, it doesn't matter if you have all the oversight in the world, it's not going to make a difference.
I think the other idea for Andy's idea was that something that Director Mueller did is that it would be necessary for the person who is heading up the red team for that position to be viewed as one with sufficient clout and not become a backwater. So one of the ways in which Director Mueller did that is the person who was the head of inspections was somebody who was really well respected. Everybody knew that was a really good position to have, and people wanted it, because otherwise, if you don't do that and you don't do that he created a compliance program, same thing. He had that person be an assistant director who was incredibly well respected, and you knew that the director had that person's back. But if you don't do that, I fear that you'd create this entity, but it just wouldn't have the real strength and ability to do what it needs to do.
Yeah. This actually brings me to my next question, which is what happens to agents who make errors or omit relevant information from FISA applications, and what should happen?
So I can speak to the field and what happens a little bit at headquarters, and Andy, you should chime in. But I mean, so if in the field you have an agent who has lied to you or withheld Brady intentionally, their career is over. What happens is the U.S. Attorney's Office would call up the FBI and say, that person is never appearing in this district. I mean, the FBI is in an unbelievably tough position at that point. I mean, the person really can't be alone on searches. They can't ever be swearing things. I mean, there really are consequences. The issue to me is making sure it's identified and people are acting on it. But it can be really severe if that happens.
That's true. I think we have yet another example from the IG report of maybe the difference there. So you have an FBI headquarters attorney who's accused of actually, I don't know what the accusation would be, but essentially manipulating an email to change the substance of a response to a question that he had received from the agent, which was essentially responsive to a question from the DOJ attorney. That's I don't know if that happened or not. It's a matter under investigation, so I won't weigh in on that. But if that allegation is true, cuts to the very core of everything that the FBI considers important. It's an unbelievably serious allegation of intentional misconduct.
I think he admitted it.
No, I don't think so.
I don't know that. But in any case, so that person or this person would typically be put through that inspection division OPR process and could be held accountable at a very high level. The examples that the IG gives of the errors and omissions in the FISA in which he says he did not uncover any evidence of intentionality is a much tougher place. So there are levels of accountability in the FBI that don't involve OPR and suspensions and all that kind of thing, or being essentially PNG'd from working in court. There are performance reviews. There are definitely. It kind of hits on that kind of age-old. Is it an intentional thing or is it a performance issue? Somebody just, intentionally obfuscating things, or are they just bad at their job and should be moved into a position of less sensitivity? So there's a kind of a range of different ways to approach it. But I think your comments earlier are spot on. I don't know that level of accountability and the immediacy of accountability that we should have attached to the FISA process has been effectively communicated to those people who are involved in it. And that gets to the cultural change that the Bureau needs to work on.
So this is going to be my last question before we go to the cards. But so, the president and his allies have argued that the IG report shows an FBI that is institutionally biased against the president. And although the IG report found no evidence of political bias, Horowitz somewhat pointedly testified that he did not reach the conclusion that there was no political bias. And just the distinction here is he didn't find evidence of bias, but he does not affirmatively rule it out either. Is there any truth to the claims of the president and his defenders? Are there other types of institutional bias in the Bureau that Americans should be concerned about?
Political bias? No. There's no truth to that. And to be clear, the IG's response to that question was he found no evidence of political bias in this report or in the prior report on the Hillary Clinton email investigation. But he said he didn't like the answers he got to some of the questions he asked. And for that reason, he wasn't willing to make a stronger statement about it. And I'll certainly invite Andrew to contribute from his experience working in the FBI. Is it possible that people in the FBI have inherent biases, cultural biases, all sorts of things that every American has? Certainly that's possible. What I did not see in the FBI, not in 2016 or 2017 or in any of the other 19 years I spent in the organization before that, was the introduction of political bias to the work that we do. FBI people have political opinions. They hopefully vote and involve themselves in the democratic process. But it is pointedly a place where those personal concerns are not relevant to the work you do. We never found it, I don't think in my time in the Bureau, we were ever in a situation where that crossroads of personal political opinion and the work that we were doing seemed to overlap. But the fact is, and having been involved in many of the most important decisions of those cases, I can tell you that political bias did not play a role in them.
I would say one of the things that's really unusual going from the main justice, the Department of Justice, I mean, obviously the FBI is part of that, but going across the street to the FBI, I had this experience, and my friends who had the same experience going from main justice to the FBI is it is palpable that the people at the FBI are just constitutionally brought up to be, I think, what you'd want in terms of they're apolitical and dedicated. It's not to say that there clearly were mistakes here, and there's serious mistakes, but the idea that the FBI has, as an institution, has one and only one political appointee, and that's the director. That is different than every other part of the intelligence community, where there are many, many, many political appointees. And it's really felt within the Bureau. People really understand that it is just the facts and just the law. And it's really a remarkable thing. I mean, it makes you, it really hits you just when you make that transition, how different it is. And so in terms of the culture, I think that there's so many great things about the culture at the FBI. I think that, I really think it's a matter of structurally getting other players in and training and auditing. But I don't think it's a question of dedication or people having political biases.
I mean, I wish that were the case, because that would be an easy fix, right? One, you don't have much of a problem. There's, what percentage of FISAs every year have anything to do with domestic politics? Maybe a couple.
0 to 1.
Right, 0 to 1. So, hey, you have a problem that's isolated to cases like this. You fire a few people. You maybe institute a limited extra set of review for this tiny fraction of special investigative matters, but it's not, a cause for more systemic concern. So that would be, in some sense, reassuring if that were the cause. But I don't think the IG report, or the sort of the timeline of how things occurred, gives you much reason to think that that was a serious. You can't rule it out because you can't read people's minds, and people may not themselves be aware of every form of bias that affects their decision when they have to make judgment calls. But the overall picture in the report is not that that is the primary, I think, part of the story. I mean, for one, before he joined, or at least shortly after he joined the campaign, it was already in the works. The sort of Trumpiest FBI field office, the New York office, had already opened a counterintelligence investigation on Page for reasons really unrelated to Russia or collusion or election
Unrelated
anything.
to the election.
Yeah,
Certainly
unrelated
related to Russia.
well, right, related to Russia, not related to the election. So, the initial interest in him was not plausibly about the anticipation that he would become a Trump advisor.
And I won't repeat everything I said earlier, but regardless of whether there's evidence of political bias with a capital T against one party or another party, there certainly have been things that have happened that have raised the specter of other kinds of bias, including anti-Muslim bias. There were also some FBI training materials that were blatantly Islamophobic that came out through Freedom of Information Act requests. Evidence of racial bias, evidence of certainly bias against left-leaning advocacy groups. So, and I'm not saying this permeates every aspect of the FBI, but we can't deny some of the evidence that it's there. And of course, my fear in all of this is that if there is a FISA application that is affected by one of those biases, and therefore the agent has slanted the facts or skewed the facts in that application, what we have learned is that the system that's in place right now is not adequate to uncover that.
So this is the first question from the audience. Yesterday, the newly appointed amicus to the court, David Chris, submitted a brief saying that the FBI's promised reforms following the IG report were not sufficient and proposed an additional set of reforms. What does the panel think of his assessment and his proposals?
So let me start by saying that I think that David is a really great lawyer and has the perfect background for submitting this. I'm not an advocate of just because he was part of NSD, he doesn't have something very valuable to say. And he was operating under a short period of time. So that's all the disclaimers. I was a little disappointed. I didn't think it went far enough. I think that the suggestions from the people on this panel get more to the heart of some of the issues. I mean, I'm not saying all of them could be done, but I think that there needs to be a wider conversation. But I do, to say, end on a positive note, I agreed with him that I didn't think that I thought it was great that the department, along with Director Ray, were saying they're going to do a whole series of reforms, and I agree with him that they did not go far enough.
Reportedly, something like 95 to 99% of FISA applications are granted. Is that still the case? And if so, does it suggest that reforms are needed not just on the side of the applications and the addition of amicus, but also with regard to judges, i.e. their training, preparation, ability to question applications, et cetera?
Well, I don't know if that's still the case because I'm not a part of the system anymore, but it certainly was when I was involved in it. I think those numbers are a little bit misleading, not because they're inaccurate, but because they don't fully represent like how the system works. So the packages are typically shared with the court in a read copy before they're actually submitted for signature. So the clerk and sometimes the judge will have the opportunity to go through the entire package. If they have questions or concerns about the package, those come back to the department, and those questions have to be ironed out before the package goes forward. Many times that results in packages being pulled completely for additional investigation or further evaluation of a source or whatever might be thought necessary. So because of that very close back and forth kind of transparent process as the packages are being developed, packages that aren't likely to be signed don't go to the court. So I think that's what results in that pretty high number.
That actually bothers me a little, the fact that that happens, because that's not how courts usually act with a party that comes before the court. They don't usually work with them to make sure that the pleadings that are being submitted are good enough, and that to make sure that that person is actually going to win, is actually going to succeed. The closeness that I've often read about between the staff of the FISA court and the staff of the National Security Division, it may be inevitable in the context of this little insular world, but I think it's part of the problem, because I think that they see themselves, the court and the Department of Justice, as working together toward a common shared goal. And that is not what a neutral judicial body is. That's not how a neutral judicial body is supposed to view its role. So I think that's actually a little problematic.
So the one thing I will say is in the criminal context, there is that back and forth. If you submit a search warrant or a Title III that has a deficiency, the court will alert you that there's a problem and say, I'm not sure about this, or do you have more evidence of that, because I'm not, I don't think this meets the standard. So there is a back and forth. I do agree with you. In other words, I don't think that's unusual. One of the proposals I'd have is that if there's an increased amicus role, they should be part of that back and forth with the staff. I mean, there's no reason not to. If they're cleared, I think it's very useful to have a third party there to be hearing what's going on. And I think another reason for that is I think it's great that the FISA judges are Article III judges and have the criminal background, but that means that the FISA process has a lot of technicalities, as Andy knows. And so the judges do rely a lot because they have their actual, when you're on the FISC, you have your normal Article III job to do, and you do your FISA work. So there is a lot of reliance on the staff. And so I think that is also a bit of a problem, because you don't have the same expertise in the judges. But I think you do want them. I would never be an advocate for just having a specialized court with specialized judges, because I think the background of having the Article III setting is great.
I would note, you take this as either reassuring or disturbing as you prefer, but I think the approval rate for Title III wiretap applications is also north of 90. I think it's in the mid to high 90s. I don't remember the number from the most recent administrative office report, but it's not that much lower than the FISA rate. In terms of the composition of judges, I think maybe it's worth noting the FISC is pretty unusual in that it is composed of 11 people chosen by one person. Every member of this court is unilaterally picked by the Chief Justice of the Supreme Court. So it means essentially all of these people have been chosen by John Roberts. And this is not to sort of impugn any of the current sitting FISA judges or say that they're bad choices, but that may be a process that doesn't give you an interesting sort of diversity or as much diversity of perspectives as you might get through a different process. And just essentially no other court in the country that works that I can think of that way, where one person simply picks every member of the court.
And just before we close this one out, I don't want to misrepresent it as some sort of rubber stamp, like the verdict's already in before the package arrives. That is not the case. The judges also have the ability and frequently demand that the affiant, which on a FISA request is not the case agent, but it's that headquarters supervisor I described earlier. They may want the affiant to come in and be questioned. I think that process could greatly benefit from the involvement of the amicus or a standing group, red team, whatever we're calling it, to be able to get closer to that level of kind of confrontation and adversarial process before the decisions are rendered.
I guess I'm going to do one more question. What should Congress's role be going forward in terms of DOJ, internal DOJ, FBI reform? And what are your realistic assessments of progress on the Hill?
That could be a very short answer.
I guess, I mean, one way to ask the question is Congress necessary? Like, does Congress have to change the law to make some of these things happen? And, you know.
For an increased amicus role, for most of it, the court could do it. But there are a number of proposals, and I would encourage you to look at Just Security, that I think would need congressional approval, having to do with notices to FISA recipients and standing for an amicus to appeal an adverse decision. I mean, there are a variety of issues that I think you would need Congress to take up.
Well, I just had, we haven't really talked about it. I think it's worth mentioning, right? The opportunity or the occasion on which any reform is likely to get pushed forward is the pending sunset of certain other sort of Patriot Act adjacent authorities that mostly have to do with metadata. And it's a kind of weird lacuna in the IG report. It's pretty inconceivable that the first sort of investigative measure taken is a full content Title I FISA on page, right? They have a lot of other targets, tools that are easier to obtain that don't require this full probable cause showing. Section 215 that lets you get business records. Section 214 that lets you get real-time metadata on communications, like internet communications or telephone communications. National security letters don't require a judge to get a range of financial and telecommunications records. It seems very unlikely that these tools were not used. We don't hear anything about them in the IG report, really, or almost nothing, which strikes me as odd. I'm curious whether there were problems with the use of those as well. But also, the way the statute is written, once you have someone who's believed to be an agent of a foreign power, everyone in their social circle, anyone in communication with or known to that person, is now essentially presumptively liable to the use of these tools. So if you submit an application for one of these other authorities to the court and say, we think Carter Page is an agent of a foreign power, which of course that's the showing they have to make for the FISA, these people, the entire senior campaign staff of the Trump campaign, are known to or in communication with him. The way the statute is written, the court is required to find those people's records relevant to an investigation and therefore accessible to the government using these tools. And this is pretty detailed and invasive stuff. So in terms of a role for Congress, since the context in which this has likely come up involves renewing those authorities, I think it's worth looking at whether that should be written in such a way that a sort of targeting page makes this entire universe of other people subject to a, in practice, not that much less intrusive, perhaps, form of surveillance, given how much detail is in people's metadata.
Well, that's it for us. Thank you so much for coming, and please give our panelists a hand.